Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we're shifting gears a little bit and doing a contract law decision. Don't worry, it's not about a boat, so, calm down, because most first-year contracts... I know! I learned more about boats in first-year contracts than I think I learned about anything else. So much boat knowledge I have now. But today we're going to do Bhasin and Hrynew, which is a recent-ish decision. It's from 2014, and it established the freestanding duty of good faith in contractual negotiations, which, as you probably remember, Zach, the Supreme Court doesn't like to tell people how they can contract with each other. It's not a thing that they do very often. So do you remember reading this one in 1L?
I do remember reading this, and I'm going to throw this out as a caveat for any of our students who listened. I did absolutely terrible in contracts in my first year. It was one of my lowest marks I ever got in my entire life. But I still remember some of these cases and why they're important, especially good faith. Oh my goodness, does good faith come up all the time in all sorts of areas of law?
It's funny because what you and me are currently doing is very unrelated to this decision. And this case has come up 3 times since I've been articling. And even though what I'm currently doing isn't really at all related to private party contractual negotiations, and it's still come up. So it's weird how something you wouldn't really think. It's about insurance salesmen in Alberta and sort of a semi-squeeze out situation where they tried to force this guy out of business. And you wouldn't think that would have anything to do with anything. And it comes up a lot in what I'm doing now, which is totally unrelated. So the freestanding duty of good faith comes up a lot. And yeah, I loved first year contracts, but that's just because it's my goal in life to be Claire Mamet when I grow up. And I tell that to everyone all the time. And she is my absolute favorite professor ever. So I keep doing this on the podcast. I keep just using it as an opportunity to stan the women professors I loved so much. But oh well, too bad. I'm driving the bus.
That's why we did the podcast, right?
Literally. But no, it's definitely an interesting decision because, as anyone who's taken contracts would know, or anyone who is about to, courts are very reticent to interfere when private parties who are of equal sort of standing negotiate an agreement amongst themselves. They don't like to do it because the power of private parties to contract with one another on their own terms is almost sacrosanct, really. It's very, very respected. They almost never interfere. Obviously, there are exceptions like undue influence or unconscionability when the parties are unequal, that sort of thing. But when the two parties are sort of on equal footing, the court's not regularly going to interfere with something like that, really, because they just don't see it as their business. Power of contract is a powerful thing in Canadian law.
It is.
Yeah.
And I think it's really cool too if you're at all interested in philosophy or political philosophy, if you really want to deep dive into why that is, you start to pull back the writings from the 18th century, early to late Enlightenment, when you start pulling apart things like the Leviathan and the free hand of the market and stuff. You start to pull these cases about this stuff apart and you're oh, this is why the courts don't want to get involved, because it's deeply rooted in the architecture of the way Canadian society operates. Whether you agree with it or not, that's just the way it is.
Oh yeah, that's why in contracts so many of the decisions are so old. When you're learning 1L contract law, so many of the decisions you read are very old decisions. And it's well, they're old for a reason. We really honestly have valued the power of contract since the Industrial Revolution, and not a whole lot has changed in terms of how we view it. I would say we view it equally as importantly now as we did then. And courts are not going to interfere with that. So I know them, imposing this freestanding duty was a huge deal. It was a very, very,
massive,
very big deal. Yeah, this is definitely a decision you're going to read in 1L, and it's probably one of the most important contract law decisions that has ever been written, really, by the SCC.
Yeah, and it reminds me a little bit of we talked about Stinchcombe a while ago, right?
Yeah.
And we were discussing about how it's kind of a turning point in that area of law. Mm-hmm. This is essentially the same thing, because if you think about it, for basically our entire lives, for the most part, this good faith duty has existed. But before that, akin to like the Wild West where there was no rule
Definitely.
effectively, right? And so the court stepping in is, to legal geeks like us, is like a huge deal.
Well, I mean, I don't think you get Uber and Heller if you don't have Bhasin and Hrynew, right? Like, I don't think that the decision is possible without this one. So, well, we clearly love it. So we hope you guys too, and enjoy the listen. Bhasin and Hrynew. Heard before the Supreme Court of Canada. Heard on February 12th, 2014, and on November 13th, 2014. The judgment of the court was delivered by Justice Cromwell. Part 1. Introduction. The key issues on this appeal come down to two straightforward questions. Does Canadian common law impose a duty on parties to perform their contractual obligations honestly? And, if so, did either of the respondents breach that duty? I would answer both questions in the affirmative. Finding that there is a duty to perform contracts honestly will make the law more certain, more just, and more in tune with reasonable commercial expectations. It will also bring a measure of justice to the appellant, Mr. Bhasin, who was misled and lost the value of his business as a result. Part 2. Facts and Judicial History. Overview and Issues. The appellant, Mr. Bhasin, through his business, Bhasin & Associates, was an enrollment director for Canadian American Financial Corporation, Can-Am, beginning in 1989. The relationship between Mr. Bhasin and Can-Am soured in 1999, and ultimately, Can-Am decided not to renew the dealership agreement with him. The litigation leading to this appeal ensued. Can-Am markets education savings plans, ESPs, to investors through retail dealers, known as enrollment directors, such as Mr. Bhasin. It pays the enrollment directors compensation and bonuses for selling ESPs. The enrollment directors are in effect small business owners, and the success of their business depends on them building a sales force. It took Mr. Bhasin approximately 10 years to build his sales force, but his business thrived, and Can-Am gave him numerous awards and prizes, recognizing him as one of their top enrollment directors in Canada. An enrollment directors agreement that took effect in 1998 governed the relationship between Can-Am and Mr. Bhasin. That agreement replaced a previous agreement of an indefinite term that had governed their relationship since the outset in 1989. The agreement was a commercial dealership agreement, not a franchise agreement. There was no franchise fee, and it was not covered by the statutory duty of fair dealing, such as that provided for in Section 7 of the Franchises Act. That said, there were some features of the 1998 agreement that are similar to provisions typically found in franchise agreements. Mr. Bhasin was obliged to sell Can-Am investment products exclusively and owed it a fiduciary duty. Can-Am owned the client lists, was responsible for branding, and implemented central policies that applied to all enrollment directors. Mr. Bhasin could not sell, transfer, or merge his operation without Can-Am's consent, which was not to be withheld unreasonably. The term of the contract was 3 years. Clauses 8.3 and 8.4 allowed termination on short notice for misconduct or other cause. Clause 3.3, the provision at the center of this case, provided that the contract would automatically renew at the end of the 3-year term unless one of the parties gave 6-month written notice to the contrary. Mr. Hrynew, one of the respondents and other enrollment director, was a competitor of Mr. Bhasin, and there was considerable animosity between them. The trial judge found, in effect, that Mr. Hrynew pressured Can-Am not to renew its agreement with Mr. Bhasin, and that Can-Am dealt dishonestly with Mr. Bhasin and ultimately gave in to that pressure. When Mr. Hrynew moved his agency to Can-Am from one of its competitors many years before the events in question, Can-Am promised him that he would be given consideration for mergers that would take place and he in fact merged with other agencies in Calgary after joining Can-Am. He was in a strong position with Can-Am because he had the largest agency in Alberta and a good working relationship with the Alberta Securities Commission, which regulated Can-Am's business. Mr. Hrynew wanted to capture Mr. Bhasin's lucrative niche market around which he had built his business. Mr. Hrynew personally approached Mr. Bhasin to propose a merger of their agencies on numerous occasions. He also actively encouraged Can-Am to force the merger and made veiled threats that he would leave if no merger took place. The trial judge found that the proposed merger was in effect a hostile takeover of Mr. Bhasin's agency by Mr. Hrynew. Mr. Bhasin steadfastly refused to participate in such a merger. The Alberta Securities Commission raised concerns about compliance issues among Can-Am's enrollment directors. In late 1999, the Commission required Can-Am to appoint a single provincial trading officer, a PTO, to review its enrollment directors for compliance with securities laws. Can-Am appointed Mr. Hrynew to that position in September of that year. The role required him to conduct audits of Can-Am's enrollment directors. Mr. Bhasin and Mr. Hahn, another enrollment director, objected to having Mr. Hrynew, a competitor, review their confidential business records. Can-Am became worried that the commission might revoke its license, and in 1999 and 2000, it had many discussions with the commission about compliance. During those discussions, it was clear that Can-Am was considering a restructuring of its agencies in Alberta and involved Mr. Bhasin. During those discussions, it was clear that Can-Am was considering a restructuring of its agencies in Alberta that involved Mr. Bhasin. In June 2000, Can-Am outlined its plans to the Commission, and they included Mr. Bhasin working for Mr. Hrynews' agency. The trial judge found that this plan had been formulated before June 2000. None of this was known to Mr. Bhasin. In fact, Can-Am repeatedly misled Mr. Bhasin by telling him that Mr. Hrynew, as PTO, was under an obligation to treat the information confidentially and that the Commission had rejected a proposal to have an outside PTO, neither of which was true. It also responded equivocally when Mr. Bhasin asked in August 2000 whether the merger was a, quote, done deal, end quote. When Mr. Bhasin continued to refuse to allow Mr. Hrynew to audit his records, Can-Am threatened to terminate the 1998 agreement and in May 2001 gave notice of non-renewal under the agreement. At the expiry of the contract term, Mr. Bhasin lost the value of his business in his assembled workforce. The majority of his sales agents were successfully solicited by Mr. Hrynews' agency. Mr. Bhasin was obliged to take less remunerative work with one of Can-Am's competitors. Mr. Bhasin sued Can-Am and Mr. Hrynew. Justice Moen in the Alberta Court of Queen's Bench found that it was an implied term of the contract that decisions about whether to renew the contract would be made in good faith. The court held that the corporate respondent was in breach of the implied term of good faith, that Mr. Hrynew had intentionally induced breach of contract, and that the respondents were liable for civil conspiracy. The trial judge found that Can-Am acted dishonestly with Mr. Bhasin throughout the events leading up to the non-renewal. It misled him about its intentions with respect to the merger and about the fact that it had already proposed the new structure to the Commission. It did not communicate to him that the decision was already made and final, even though he asked, and it did not communicate with him that it was working closely with Mr. Hrynew to bring about a new corporate structure, with Hrynews being the main agency in Alberta. The trial judge also found that, had Can-Am acted honestly, Mr. Bhasin could have governed himself accordingly so as to retain the value in his agency. The Alberta Court of Appeal allowed the respondent's appeal and dismissed Mr. Bhasin's lawsuit. The court found his pleadings to be insufficient and held that the lower court erred by implying a term of good faith in the context of an unambiguous contract containing an entire agreement clause. The appeal raises 4 issues. A. Did Mr. Bhasin properly plead breach of the duty of good faith? B. Did Can-Am owe Mr. Bhasin a duty of good faith? If so, did it breach that duty? C. Are the respondents liable for the torts of inducing breach of contract or civil conspiracy? D. If there was a breach, what is the appropriate measure of damages? Part 3. Analysis. A. Did Mr. Bhasin properly plead breach of the duty of good faith? The Court of Appeal held that Mr. Bhasin had not properly pleaded the good faith issue and that the trial judge had therefore erred in considering it. Mr. Bhasin contests this conclusion, while the respondents support it. I agree with Mr. Bhasin. The allegations in the statement of claim clearly put the questions of improper purpose and dishonesty in issue. These facts are sufficient to put Can-Am's good faith in issue. The question of whether this conduct amounted to a breach of the duty of good faith is a legal conclusion that did not need to be pleaded separately. The defendants did not move to strike the pleadings or seek particulars of the allegation of wrongful termination in the statement of claim. Good faith was a live issue that was fully canvassed in a lengthy trial. Written submissions by both parties at the trial referred to the good faith issue, and, even in his opening at trial, Mr. Bhasin's counsel raised the issue of good faith. The trial judge held that any deficiency in the pleadings did not cause prejudice to the respondents. This is an assessment she was uniquely positioned to make, and her conclusion ought to be treated with deference on appeal. The good faith issue was fully argued in and addressed by the Court of Appeal and has been fully argued on its merits in this court. In my view, the trial judge did not make a reversible error by adjudicating the issue of good faith, and we should address the merits of that issue. B. Did Can-Am owe Mr. Bhasin a duty of good faith? 1. Decisions and positions of the parties. Decisions. The trial judge accepted Mr. Bhasin's position that there was a duty of good faith in this case and that it had been breached. In brief, her reasoning was as follows. First, the trial judge decided that the 1998 agreement was a type of agreement which as a matter of law requires good faith performance. She recognized that the 1998 agreement did not fall within any of the existing categories of contract, such as employment, insurance, and franchise agreements, which have been held to require good faith performance. She concluded, however, that the agreement was analogous to a franchise or employment contract, and so by analogy to these cases, she implied a term of good faith performance as a matter of law. The contract was not balanced from its inception, and the relationship placed the enrollment director in a position of inherent and predictable vulnerability. Second, and in the alternative, the trial judge held that a term of good faith performance should be implied based on the intentions of the parties in order to give business efficacy to the agreement. She concluded that, quote, when one considers the whole of the relationship, it is clear that the parties had to operate in good faith and there was a requirement of fairness between them. In other words, good faith was necessary to give business efficacy to the whole 1998 agreement, end quote. The 1998 agreement contained an entire agreement clause stating that there were no, quote, agreements express, implied, or statutory other than expressly set out, end quote. The trial judge held, however, that this clause did not preclude the implication of a duty of good faith. The parties, she reasoned, cannot rely on exclusion clauses to avoid contractual obligations where there is an imbalance of power, and courts refuse to let parties shelter under entire agreement clauses when it would be unjust or inequitable to do so. Turning to the issue of breach, the trial judge found that Can-Am had breached the agreement, first by requiring Mr. Bhasin to submit to an audit by Mr. Hrynew and to provide the latter with access to his business records, and second, by exercising the non-renewal clause in a dishonest and misleading manner and for an improper purpose. The non-renewal clause was not intended to permit Can-Am to force a merger of the Bhasin and Hrynew agencies, but that was the purpose for which Can-Am exercised this power. The trial judge also found both respondents liable for unlawful means conspiracy and found Mr. Hrynew liable for inducing Can-Am's breach of its contract with Mr. Bhasin. The Court of Appeal reversed and held that there had been no breach of contract. The duty of good faith in employment contracts could not be extended by analogy to other types of contract. In any event, the duty of good faith in the employment context is limited to the manner of termination and does not include reasons for non-renewal. Nor was this a circumstance in which the term could be implied because it was so obvious it was not thought necessary to mention or was necessary to make the contract work. Even if there were an implied duty of good faith in this case, the impugned conduct concerned the non-renewal of a contract, which occurs on expiry, unlike a termination clause. Moreover, the Court of Appeal held that a term cannot be implied where it goes against an express term of the contract. Here, the parties did not intend a perpetual contract, since they included a term allowing either party to unilaterally trigger its expiration prior to the end of each 3-year term. The trial judge's approach was inconsistent with the non-renewal provision of the contract. The motive for triggering expiration was not restricted under the agreement. The implication of a term of good faith also violated the entire agreement clause. The court held that the evidence of assurances given by Can-Am as to how the non-renewal power would be exercised fell afoul of the parole evidence rule and should not have been considered. Since the Court of Appeal held that there was no breach of contract, the basis for the claims in unlawful means conspiracy and inducing breach of contract also disappeared. Positions of the parties. Mr. Bhasin advances 2 related positions on appeal. His broad submission is that the court should recognize a general duty of good faith in contract. The duty arises where the agreement gives the defendant the power to unilaterally defeat a legitimate contractual objective of the plaintiff, and it does not clearly allow the defendant to exercise its power without regard for that objective. This duty of good faith prevents conduct which, while consonant with the letter of a contract, exhibits dishonesty, ill will, improper motive, or similar departures from reasonable business expectations. Mr. Bhasin contends that common law in Canada is increasingly isolated as other jurisdictions embrace a greater role for good faith in contract law. The recognition of a general duty of good faith would constitute an incremental advance in the law, given the numerous specific situations that already give rise to a duty of good faith. Mr. Bhasin relies on the findings of the trial judge that the respondents improperly and dishonestly used their non-renewal right to compel Mr. Bhasin to merge with his competitor. Mr. Bhasin contends that the respondents had no legitimate business reason for not renewing the contract. He also says that the entire agreement clause should be construed narrowly, and that express language is needed for such a clause to derogate from a duty of good faith. Mr. Bhasin's second position, emphasized in oral argument, is that the court should at least recognize a duty of honest performance of contractual obligations. Mr. Bhasin relies on the trial judge's findings that Can-Am acted dishonestly towards Mr. Bhasin throughout the period leading up to the non-renewal. It repeatedly lied to him about the nature of the organizational changes required by the Alberta Securities Commission, the nature of the audits that were to be carried out by Mr. Hrynew, and was dishonest about its intention to force him out. Unsurprisingly, the respondents see things very differently. While they accept that good faith plays a role in Canadian contract law, they submit that this role is much more modest than Mr. Bhasin suggests. They say that such a duty arises only in certain classes of contract, such as employment contracts and in contracts involving discretionary powers. In the employment context, the duty applies only to the manner in which a contract is terminated. The contract in this case was negotiated between commercial parties to whom the policy considerations underlying employment law doctrine do not apply. Mr. Bhasin is alleging a right to a perpetual, or at least indefinite, contract with the respondents. The contract in this case could not be said to be discretionary because it provided simply that on 6 months' notice, either party could terminate the agreement. The respondents submit that there is no ambiguity in the wording of the non-renewal clause of the contract, and so there is no basis for implying that other terms or for relying on extrinsic evidence of the parties' intentions. The entire agreement clause specifically precluded the implication of any terms other than the express terms of the contract. 2. Analysis. Overview. The notion of good faith has deep roots in contract law and permeates many of its rules. Nonetheless, Anglo-Canadian common law has resisted acknowledging any generalized and independent doctrine of good faith performance of contracts. The result is a, quote, unsettled and incoherent body of law, end quote, that has developed piecemeal and which is difficult to analyze. This approach is out of step with the civil law of Quebec and most jurisdictions in the United States and produces results that are not consistent with the reasonable expectations of commercial parties. In my view, it is time to take 2 incremental steps in order to make the common law less unsettled and piecemeal, more coherent, and more just. The first step is to acknowledge that good faith contractual performance is a general organizing principle of the common law of contract, which underpins and informs the various rules in which the common law, in various situations and types of relationships, recognizes obligations of good faith contractual performance. The second is to recognize, as a further manifestation of this organizing principle of good faith, that there is a common law duty which applies to all contracts to act honestly in the performance of contractual obligations. In my view, taking these 2 steps is perfectly consistent with the court's responsibility to make incremental changes in the common law when appropriate. Doing so will put in place a duty that is just, that accords with the reasonable expectations of commercial parties, and that is sufficiently precise that it will enhance rather than detract from commercial certainty. Good faith as a general organizing principle. Background. The doctrine of good faith traces its history to Roman law and found acceptance in early English contract law. For example, Lord Northington wrote in Aylin and Belcaire in 1758 that, quote, no point is better established than that a person having a power must exercise it bona fide for the end designed, otherwise it is corrupt and void, end quote. Similarly, Lord Kenyon wrote in Mellish and Moteau, quote, in contracts of all kinds, it is of the highest importance that courts of law should compel the observance of honesty and good faith, end quote. In Carter and Boehm, Lord Mansfield stated that good faith is a principle applicable to all contracts. See also Herbert and Mercantile Fire Insurance. However, these broad pronouncements have been, for the most part, restricted by subsequent jurisprudence to specific types of contracts and relationships, such as insurance contracts, leaving unclear the role of the broader principle of good faith in modern Anglo-Canadian law of contracts. One leading Canadian contract scholar went so far as to say that the common law has taken a, quote, kind of perverted pride, end quote, in the absence of any general notion of good faith, as if accepting that notion, quote, would be admitting to the presence of some kind of embarrassing social disease, end quote. The court has not examined whether there is a general duty of good faith contractual performance. However, there has been an active debate in other courts and among scholars for decades over whether there is, or should be, a general or standalone duty of good faith in the performance of contracts. Canadian courts have reached different conclusions on this point. Some suggest that there is a general duty of good faith. They see a broad role for good faith as an implied term in all contracts that establishes minimum standards of acceptable commercial behavior. As Justice Kelly put in Gateway Realty, quote, the law requires that parties to a contract exercise their rights under that agreement honestly, fairly, and in good faith. The standard is breached when a party acts in a bad faith manner in the performance of its rights and obligations under the contract. Good faith conduct is the guide to the manner in which the parties should pursue their mutual contractual objectives. Such conduct is breached when a party acts in bad faith, a conduct that is contrary to community standards of honesty, reasonableness, and fairness. Other courts are of the view that there exists no such general duty of good faith in all contracts. The detractors of such a general duty of good faith have accepted a limited role for good faith in certain contexts, but have held that it would create commercial uncertainty and undermine freedom of contract to recognize a general duty of good faith that would permit courts to interfere with express terms of a contract. This court ought to develop the common law to keep in step with the, quote, dynamic and evolving fabric of our society, end quote, where it can do so in an incremental fashion and where the ramifications of the development are not incapable of assessment. This is even more appropriate where, as here, what is contemplated is not the reversal of some settled rule, but a development directed to bringing greater certainty and coherence to a complex and troublesome area of the common law. As I see it, the developments that I propose are desirable as a result of several considerations. First, the current Canadian common law is uncertain. Second, the current approach to good faith performance lacks coherence. Third, the current law is out of step with the reasonable expectations of commercial parties, particularly those of at least two major trading partners of common law Canada, Quebec and the United States. While the developments which I propose will not completely address these problems, they will bring a measure of coherence and predictability to the law and will bring the law closer to what reasonable commercial parties would expect it to be. Survey of the current state of the common law. Anglo-Canadian common law has developed a number of rules and doctrines that call upon the notion of good faith in contractual dealings. It is a concept that underlies many elements of modern contract law. The approach, not unfairly, has been characterized as developing piecemeal solutions in response to demonstrated problems. Thus, we see, for example, that good faith notions have been applied to particular types of contracts, particular types of contractual provisions, and particular contractual relationships. It also underlies doctrines that explicitly deal with fairness in contracts, such as unconscionability, and plays a role in interpreting and implying contractual terms. The difficulty with this piecemeal approach, however, is that it often fails to take a consistent or principled approach to similar problems. A brief review of the current landscape of good faith will show the extent to which this is the case. Considerations of good faith are apparent in doctrines that expressly consider the fairness of contractual bargains, such as unconscionability. This doctrine is based on considerations of fairness and preventing one contracting party from taking undue advantage of the other. Good faith also plays a role in the law of implied terms, particularly with respect to terms implied by law. Terms implied by law redress power imbalances in certain classes of contracts, such as employment, landlord-leasee, and insurance contracts. The implication of terms plays a functionally similar role in the common law contract law to the doctrine of good faith in civil law jurisdictions by filling in gaps in the written agreement of the parties. In Mesa Operating, the Alberta Court of Appeal implied a term that a power of pooling properties for the purpose of determining royalty payments be exercised reasonably. The court implied this term in order to give effect to the intentions of the parties rather than as a requirement of good faith, but as Appeal Justice Karen stated that, quote, "The rule that governs here can therefore be expressed much more narrowly than to speak of good faith, although I suspect it is in reality the sort of thing that some judges have in mind when they speak of good faith," end quote. Considerations of good faith are also apparent in contract interpretation. The primary object of contractual interpretation is, of course, to give effect to the intentions of the parties at the time of contract formation. However, considerations of good faith inform this process. Parties may generally be assumed to intend certain minimum standards of conduct. Further, as Lord Reed observed in Schiller AG and Wickham Machine Tool Sales Limited, quote, "The more unreasonable the result, the more unlikely it is that the parties can have intended it," end quote. As A. Swan and J. Adamski put it, the duty of good faith, quote, "is not an externally imposed requirement, but inheres in the parties' relation," end quote. Good faith also appears in numerous contexts in a more explicit form. The concept of good faith is used in hundreds of statutes across Canada, including statutory duties of good faith and fair dealing in franchise legislation and good faith bargaining in labor laws. There have been many attempts to bring a measure of coherence to this piecemeal accretion of appeals to good faith. By way of example, Professor McCamus has identified 3 broad types of situations in which a duty of good faith performance of some kind has been found to exist. 1, where the parties must cooperate in order to achieve the objects of the contract. 2, where one party exercises a discretionary power under the contract. And 3, where one party seeks to evade contractual duties. While these types of cases overlap to some extent, they provide a useful analytical tool to appreciate the current state of the law on the duty of good faith. They also reveal some of the lack of coherence in the current approach. It is often unclear whether a good faith obligation is being imposed as a matter of law, as a matter of implication, or as a matter of interpretation. Professor McCamus notes, quote, "Although the line between the 2 types of implication is difficult to draw, it may be realistic to assume that implied duties of good faith are likely, on occasion at least, to slide into the category of legal incidents rather than mere presumed intentions. Certainly, it would be difficult to defend the implication of terms on each of the cases considered here on the basis of the traditional business efficacy or officious bystander test. In the control of contractual discretion cases, for example, it may be more realistic to suggest that the implied limitation on the exercise of the discretion is intended to give effect to the reasonable expectations of the parties." End quote. The first type of situation, contracts requiring the cooperation of the parties to achieve the objects of the contract, is reflected in the jurisprudence of this court. In Dynamic Transport Limited and OK Detailing Limited, the parties to a real estate transaction failed to specify in the purchase-sale agreement which party was to be responsible for obtaining planning permission for a subdivision of the property. By law, the vendor was the only party capable of obtaining such permission. The court held that the vendor was under an obligation to use reasonable efforts to secure the permission. Or, as Justice Dixon as he then was put it, quote, "The vendor is under a duty to act in good faith and to take all reasonable steps to complete the sale," end quote. It is not completely clear whether this duty was imposed as a matter of law or was implied based on the parties' intentions. Mitsui & Company Canada Limited and Royal Bank of Canada is an example of the second type of situation, exercise of contractual discretion. The lease of a helicopter included an option to buy at the, quote, "reasonable fair market value of the helicopter as established by lessor," end quote. This court held that, quote, "clearly the lessor is not in a position, by virtue of Clause 32, to make any offer that it may feel is appropriate. It is contractually bound to act in good faith to determine the reasonable fair market value of the helicopters, which is the price that the parties had initially agreed would be the exercise price of the option," end quote. The court did not discuss the basis for implying the term, but suggested that in the absence of a reasonableness requirement, the option would be a mere agreement to agree, and thus would be unenforceable, which means that the implication of the term was necessary to give business efficacy to the agreement. This court's decision in Mason and Friedman falls into the third type of situation in which the duty of good faith arises, where a contractual power is used to evade a contractual duty. In that case, the vendor in a real estate transaction regretted the bargain he had made. He then sought to repudiate the contract by failing to convey title in fee simple because he claimed his wife would not provide a bar of dower. The issue was whether he could take advantage of a clause permitting him to repudiate the transaction in the event that he was, quote, "unable or unwilling," end quote, to remove this defect in title, even though he had made no efforts to do so by trying to obtain the bar of dower. Judge Judson held that the clause did not, quote, "enable a person to repudiate a contract for a cause which he himself has brought about, or permit a capricious or arbitrary repudiation," end quote. On the contrary, quote, "a vendor who seeks to take advantage of the clause must exercise his right reasonably and in good faith, and not in a capricious or arbitrary manner," end quote. The jurisprudence is not always very clear about the source of the good faith obligations found in these cases. The categories of terms implied as a matter of law, terms implied as a matter of intention, and terms arising as a matter of interpretation sometimes are blurred or even ignored, resulting in uncertainty and a lack of coherence at the level of principle. Apart from these types of situations in which a duty of good faith arises, common law Canadian courts have also recognized that there are classes of relationships that call for a duty of good faith to be implied by law. For example, this court confirmed that there is a duty of good faith in the employment context in Honda Canada Inc. and Keys. Mr. Keys was diagnosed with chronic fatigue syndrome and was frequently absent from work. Honda grew concerned with the frequency of the absences. It ordered Mr. Keys to undergo an examination by a doctor chosen by the employer, required him to provide a doctor's note for any absences, and discouraged him from retaining outside counsel. The majority held that in all employment contracts there was an implied term of good faith governing the manner of termination. In particular, the employer should not engage in conduct that is unfair or is in bad faith by being, for example, untruthful, misleading, or unduly insensitive when dismissing an employee. Good faith in this context did not extend to the employer's reasons for terminating the contract of employment because this would undermine the right of an employer to determine the composition of its workforce. This court has also affirmed the duty of good faith, which requires an insurer to deal with its insured's claim fairly, both with respect to the manner in which it investigates and assesses the claim and to the decision whether or not to pay it. The breach of this duty may well support an award of punitive damages. This duty of good faith is also reciprocal. The insurer must not act in bad faith when dealing with a claim, which is typically made by someone in a vulnerable situation. This duty of good faith is reciprocal. The insurer must not act in bad faith when dealing with a claim, which is typically made by someone in a vulnerable situation, and the insured must act in good faith by disclosing facts material to the insurance policy. This court has also recognized that a duty of good faith, in the sense of fair dealing, will generally be implied, in fact, in the tendering context. When a company tenders a contract, it comes under a duty of fairness in considering the bids submitted under the tendering process, as a result of the expense incurred by parties submitting these bids. Developments in the United Kingdom and Australia point to enhanced attention to the notion of good faith, mitigated by reluctance to embrace it as a standalone doctrine. Good faith in contract performance has received increasing prominence in English law, despite its traditional hostility to the concept. In Yam Sang, Justice Leggett held that a number of specific duties embodying good faith can be implied based on the presumed intentions of the parties according to the traditional approach for implying terms. Justice Leggett identified a number of these implied duties, including honesty, fidelity to the parties' bargain, cooperation, and fair dealing. Justice Leggett stated that, quote, a paradigm example of a general norm which underlies almost all contractual relationships is an expectation of honesty. That expectation is essential to commerce, which depends critically on trust, end quote. The Court of Appeal considered the Yam Sang decision in Mid-Essex Hospital Services NHS Trust and Compass Group UK and Ireland Limited, where it confirmed that good faith was not a general principle of English law, but that it could be an implied term in certain categories of cases. Australian courts have also moved towards a greater role for good faith in contract performance. The duty of good faith in its modern form was recognized by Appeal Justice Priestley in Renard Constructions Limited and Minister for Public Works. There is no generally applicable duty of good faith, but one will be implied into contracts in certain circumstances. The duty of good faith can be implied as a matter of law or as a matter of fact, although the cases are not always clear on the basis of which term is being implied. Australian courts have taken a broad view of what constitutes good faith. The law of good faith performance in Australia is still developing and remains unsettled. However, it is clear that the duty of good faith requires adherence to standards of honest conduct. The way forward. This selective survey supports the view that Canadian common law in relation to good faith performance of contracts is piecemeal, unsettled, and unclear. It also shows that in Canada, as well as in the United Kingdom and Australia, there is increasing attention to the notion of good faith, particularly the area of contractual performance. opponents of any general obligation of good faith prefer the traditional organic development of solutions to address particular problems as they arise. However, foreclosing some incremental development of the law at the level of principle would go beyond what most prudent caution requires and evidence an almost perverted pride, to use Swan's term, in the law's failings. Commercial parties reasonably expect a basic level of honesty and good faith in contractual dealings. While they remain at arm's length and are not subject to the duties of a fiduciary, a basic level of honest conduct is necessary to the proper functioning of commerce. The growth of longer-term relational contracts that depend on an element of trust and cooperation clearly call for a basic element of honesty in performance, but even in transactional exchanges, misleading or deceitful conduct will fly in the face of the expectations of the parties. The fact that commercial parties expect honesty on the part of their contracting partners can also be seen from the fact that it was the American Bar Association's section of corporation, banking, and business law that urged the adoption of honesty in fact in the original drafting of the Uniform Commercial Code. Moreover, empirical research suggests that commercial parties do in fact expect that their contracting parties will conduct themselves in good faith. It is, to say at least, counterintuitive to think that reasonable commercial parties would accept a contract which contained a provision to the effect that they were not obliged to act honestly in performing their contractual obligations. I conclude from this review that enunciating a general organizing principle of good faith and recognizing a duty to perform contracts honestly will help bring certainty and coherence to this area of law in a way that is consistent with a reasonable commercial expectation. Towards an organizing principle of good faith. The first step is to recognize that there is an organizing principle of good faith that underlies and manifests itself in various more specific doctrines governing contractual performance. That organizing principle is simply that parties generally must perform their contractual duties honestly and reasonably and not capriciously or arbitrarily. As the court has recognized, an organizing principle states in general terms a requirement of justice from which more specific legal doctrines may be derived. An organizing principle, therefore, is not a freestanding rule, but rather a standard that underpins and is manifested in more specific legal doctrines and may be given different weight in different situations. It is a standard that helps to understand and develop the law in a coherent and principled way. The organizing principle of good faith exemplifies the notion that, in carrying out his or her own performance of the contract, a contracting party should have appropriate regard to the legitimate contractual interests of the contracting partner. While appropriate regard for the other party's interests will vary depending on the context of the contractual relationship, it does not require acting to serve those interests in all cases. It merely requires that a party not seek to undermine those interests in bad faith. The general principle has strong conceptual differences from the much higher obligations of a fiduciary. Unlike fiduciary duties, good faith performance does not engage duties of loyalty to the other contracting party or a duty to put the interests of the other contracting party first. This organizing principle of good faith manifests itself through the existing doctrines about the types of situations and relationships in which the law requires, in certain respects, honest, candid, forthright, or reasonable contractual performance. Generally, claims of good faith will not succeed if they do not fall within these existing doctrines. But we should also recognize that this list is not closed. The application of the organizing principle of good faith to particular situations should be developed where the existing law is found to be wanting, and where the development may occur incrementally in a way that is consistent with the structure of the common law of contract and gives due weight to the importance of private ordering and certainty in commercial affairs. This approach is consistent with that taken in the case of unjust enrichment. Justice McLaughlin outlined this approach in Peel Regional Municipality and Canada. Quote, "This case presents the court with the difficult task of mediating between, if not resolving, the conflicting views of the proper scope of the doctrine of unjust enrichment. it is my conclusion that we must choose a middle path, one which acknowledges the importance of proceeding on general principles, but seeks to reconcile the principles with the established categories of recovery. The tripartite principle of general application, which this court has recognized as the basis of the cause of action for unjust enrichment, is thus seen to have grown out of the traditional categories of recovery. It is informed by them. It is capable, however, of going beyond them, allowing the law to develop in a flexible way as required to meet the challenging perceptions of justice." End quote. The flexible approach that was taken in Peel recognizes that, quote, "at the heart of the doctrine of unjust enrichment, whether expressed in terms of the traditional categories of recovery or general principle, lies the notion of restoration of a benefit which justice does not permit one to retain." End quote. In that case, this court further developed the law through application of an organizing principle without displacing the existing specific doctrines. This is what I propose to do with regards to the organizing principle of good faith. The approach of recognizing an overarching organizing principle but accepting the existing law as the primary guide to future development is appropriate in the development of the doctrine of good faith. Good faith may be invoked in widely varying contexts, and this calls for a highly context-specific understanding of what honesty and reasonableness in performance require, so as to give appropriate consideration to the legitimate interests of both contracting parties. For example, the general organizing principle of good faith would likely have different implications in the context of a long-term contract of mutual cooperation than it would in a more transactional exchange. The principle of good faith must be applied in a manner that is consistent with the fundamental commitments of the common law of contract, which generally places great weight on the freedom of contracting parties to pursue their individual self-interest. In commerce, a party may sometimes cause loss to another, even intentionally, in the legitimate pursuit of economic self-interest. Doing so is not necessarily contrary to good faith, and in some cases has actually been encouraged by the courts on the basis of economic efficiency. The development of the principle of good faith must be clear not to veer into a form of ad hoc judicial moralism or palm tree justice. In particular, the organizing principle of good faith should not be used as a pretext for scrutinizing the motives of contracting parties. Trying to organize the principle to the existing law mitigates the concern that any general notion of good faith in contract law will undermine certainty in commercial contracts. In my view, this approach strikes the correct balance between predictability and flexibility. Should there be a new duty? In my view, the objection to Can-Am's conduct in this case does not fit with any of the existing situations or relationships in which duties of good faith have been found to exist. The relationship between Can-Am and Mr. Bhasin was not an employment or franchise relationship. Classifying the decision not to renew the contract as a contractual discretion would constitute a significant expansion of the decided cases under that type of situation. After all, a party almost always has some amount of discretion in how to perform a contract. It would also be difficult to say that a duty of good faith should be implied in this case on the basis of the intentions of the parties, given the clear terms of an entire agreement clause in the agreement. The key question before the court, therefore, is whether we ought to create a new common law duty under the broad umbrella of the organizing principle of good faith performance of contracts. In my view, we should. I would hold that there is a general duty of honesty in contractual performance. This means simply the parties must not lie or otherwise knowingly mislead each other about the matters directly linked to the performance of the contract. This does not impose a duty of loyalty or of disclosure or require a party to forego advantages flowing from the contract. It is a simple requirement not to lie or mislead the other party about one's contractual performance. Recognizing a duty of honest performance flowing directly from the common law organizing principle of good faith is a modest, incremental step. The requirement to act honestly is one of the most widely recognized aspects of the organizing principle of good faith. For example, the duty of honesty was a key component of the good faith requirements which have been recognized in relation to termination of employment contracts. There is a long-standing debate about whether the duty of good faith arises as a term implied as a matter of fact or a term implied by law. I do not have to resolve this debate fully, which, as I reviewed earlier, casts a shadow of uncertainty over a good deal of the jurisprudence. I am at this point concerned only with a new duty of honest performance, and, as I see it, this should not be thought of as an implied term, but a general doctrine of contract law that imposes as a contractual duty a minimum standard of honest contractual performance. It operates irrespective of the intentions of the parties and is to this extent analogous to equitable doctrines which impose limits on the freedom of contract, such as the doctrine of unconscionability. Viewed this way, the entire agreement in Clause 11.2 of the agreement is not an impediment to the duty arising in this case. Because the duty of honesty and contractual performance is a general doctrine of contract law that applies to all contracts, like unconscionability, the parties are not free to exclude it. It is true that the Anglo-Canadian common law of contract has been reluctant to impose mandatory rules not based on the agreement of the parties, because they are thought to interfere with freedom of contract. As discussed above, however, the duty of honest performance interferes very little with freedom of contract, since parties will rarely expect that their contracts permit dishonest performance in their obligations. That said, I would not rule out any role for the agreement of the parties in influencing the scope of honest performance in a particular context. The precise content of honest performance will vary with the context, and the parties should be free in some contexts to relax the requirement of the doctrine so long as they respect its minimum core requirements. The approach I outline here is similar in principle to that in Section 1302B of the UCC. Quote, "The obligations of good faith, diligence, reasonableness, and care may not be disclaimed by agreement. The parties, by agreement, may determine the standards by which the performance of those obligations is to be measured if those standards are not manifestly unreasonable." End quote. Certainly, any modification of the duty of honest performance would need to be in express terms. A generically worded entire agreement clause, such as Clause 11.2 of the agreement, does not indicate any intention of the parties to depart from the basic tenets of honest performance. Two arguments are typically raised against an increased role for a duty of good faith in the law of contract. The first is that good faith is an inherently unclear concept and will permit ad hoc judicial moralism to undermine the certainty of commercial transactions. The second is that imposing a duty of good faith is inconsistent with the basic principle of freedom of contract. I do not have to decide here whether or not these points are valid in relation to a broad, generalized duty of good faith. However, they carry no weight in relation to adopting a rule of honest performance. Recognizing a duty of honesty and contractual performance poses no risk to commercial certainty in the law of contract. A reasonable commercial person would expect, at least, that the other party to a contract would not be dishonest about his or her performance. The duty is also clear and easy to apply. Moreover, one commentator points out that given the uncertainty that has prevailed in this area, cautious solicitors have long advised clients to take account of the requirements of good faith. A rule of honest performance, in my view, will promote, not detract from, certainty in commercial dealings. Any interference by the duty of honest performance with freedom of contract is more theoretical than real. It will surely be rare that parties would wish to agree that they may be dishonest with each other in performing their contractual obligations. Those who fear that this modest step would create uncertainty or impede freedom of contract may take comfort from experience of the civil law of Quebec and the common and statute law of many jurisdictions in the United States. The Civil Code of Quebec recognizes a broad duty of good faith which extends to formation, performance, and termination of a contract and includes the notion of the abuse of contractual rights. While this is not the place to expound in detail on good faith in the Quebec Civil Code, it is worth noting that good faith is seen as having two main aspects. The first is a subjective aspect, which is concerned with the state of mind of the actor and addresses conduct that is, for example, malicious or intentional. The second is the objective aspect, which is concerned with whether conduct is unacceptable according to the standards of reasonable people. As Baudouin and Jobin explain, quote, a person can be in good faith in the subjective sense, that is, act without malicious intent or without knowledge of certain facts, yet his or her conduct may nevertheless be contrary to the requirements of good faith in that it violates objective standards of conduct that are generally accepted in society, end quote. The notion of good faith includes, but is not limited to, the requirement of honesty in performing the contract. In the United States, Section 1304 of the UCC provides that, quote, every contract or duty within the Uniform Commercial Code imposes an obligation of good faith in its performance and enforcement, end quote. The UCC has been enacted by legislation in all 50 states. While the provisions of the UCC apply only to commercial contracts, Section 205 of the Restatement, Second of Contracts, provides for a general duty of good faith in all contracts. This provision of the Restatement has been followed by courts in the vast majority of states. The notion of good faith in the Restatement substantially followed the definition proposed by Robert Summers in an influential article where he proposed that good faith is best understood as an excluder of various categories of bad faith conduct. The general definition of good faith in the UCC is also quite broad, encompassing honesty and adherence to reasonable commercial standards. This definition was originally limited to honesty in fact, that is, a duty of honesty in performance, and was only later expanded. Honesty in performance is also a key component of good faith under the Restatement. Experience in Quebec and the United States shows that even very broad conceptions of the duty of good faith have not impeded contractual activity or contractual stability. It is also worth noting that in both the United States and Quebec, judicial developments preceded legislative action in codifying good faith. In the United States, courts had recognized the existence of a general duty of good faith before the promulgation of the UCC. Similarly, though there was no express provision of good faith in the Civil Code of Lower Canada, the court implied such a general duty from more specific provisions of the code. The duty of good faith was subsequently included in the revisions leading to the enactment of the Civil Code of Quebec. The duty of honest performance that I propose should not be confused with the duty of disclosure or fiduciary loyalty. A party to a contract has no general duty to subordinate his or her interest to that of the other party. However, contracting parties must be able to rely on a minimum standard of honesty from their contracting partner in relation to performing the contract as a assurance that if the contract does not work out, they will have a fair opportunity to protect their interests. That said, a dealership agreement is not a contract of utmost good faith, such as an insurance contract, which, among other things, obliges the parties to disclose material facts. But a clear distinction can be drawn between a failure to disclose a material fact, even a firm intention to end the contractual arrangement, and active dishonesty. This distinction explains the result reached by the court in United Roasters Incorporated and Colgate-Palmolive. The terminating party had decided in advance of the required notice period that it was going to terminate the contract. The court held that no disclosure of this intention was required, other than what was stipulated in the notice requirement. The court stated, quote, there is very little to be said in favor of a rule of law that good faith requires one possessing a right of termination to inform the other party promptly of any decision to exercise the right. A tenant under a month-to-month lease may decide in January to vacate the premises at the end of September. It is hardly to be suggested that good faith requires the tenant to inform the landlord of his decision soon after January. Though the landlord may have found earlier notice convenient, formal exercise of the right of termination in August will do, end quote. United Roasters makes it clear that there is no unilateral duty to disclose information relevant to termination. But the situation is quite different, as I see it, when it comes to actively misleading or deceiving the other contracting party in relation to performance of the contract. The duty of honest performance has similarities with the existing law in relation to civil fraud and estoppel, but is not subsumed by them. Unlike promissory estoppel and estoppel by representation, the contractual duty of honest performance does not require that the defendant intended that his or her representation be relied on, and is not subject to the uncertainty around whether estoppel can be used to found an independent cause of action. As for the tort of civil fraud, breach of the duty of honest contractual performance does not require the defendant to intend that the false statement be relied on, and breach if it supports a claim for damages according to the contractual rather than the tortious measures. Mr. Bhasin, supported by many judicial and academic authorities, has argued for wholesale adoption of a more expansive duty of good faith in contrast to the modest, incremental change that I propose. In many of its manifestations, good faith requires more than honesty on the part of a contracting party. For example, in dynamic transport, this court held that good faith in the context of that contract required a party to take reasonable steps to obtain the planning permission that was a condition precedent to the sale of property. In other cases, the courts have required that discretionary powers not be exercised in a manner that is capricious or arbitrary. In other contexts, this court has been reluctant to extend the requirements of good faith beyond honesty for fear of causing undue judicial interference in contracts. It is not necessary in this case to define, in general terms, the limits of the implications of the organizing principle of good faith. This is because it is unclear to me how any broader duty would assist Mr. Bhasin here. After all, the contract was subject to non-renewal. It is a considerable stretch, as I see it, to turn even a broadly conceived duty of good faith exercise of the non-renewal provision into what is, in effect, a contract of indefinite duration. This, in my view, is a principal difficulty in the trial judge's reasoning because, in the result, her decision turned a 3-year contract that was subject to an express provision relating to non-renewal into a contract of roughly 9 years' duration. As the Court of Appeal pointed out, in my view correctly, quote, the parties did not intend or presume a perpetual contract as they contracted that either party could unilaterally cause it to expire on any third anniversary, end quote. Even if there was a breach of a broader duty of good faith by forcing the merger, Can-Am's contractual liability would still have to be measured by reference to the least onerous means of performance, which in this case would have meant simply not renewing the contract. Since no damages flow from this breach, it is unnecessary to decide whether reliance on a discretionary power to achieve a purpose extraneous to the contract and which undermined one of its key objectives might call for further development under the organizing principle of good faith in contractual performance. I note as well that even in jurisdictions that embrace a broader role for the duty of good faith, plaintiffs have met with only mixed success in alleging bad faith failure to renew a contract. Some cases have treated non-renewal as equivalent to termination and thus subject to a duty of good faith. Other courts have seen non-renewal as fundamentally different, especially where the express terms of the contract contemplate the expiry of contractual obligations and leave no room for any sort of duty to review. I conclude that at this point in the development of Canadian common law, adding a general duty of honest contractual performance is an appropriate incremental step, recognizing that the implications of the broader organizing principle of good faith must be allowed to evolve according to the same incremental judicial approach. A summary of the principles is in order. 1. There is a general organizing principle of good faith that underlies many facets of contract law. 2. In general, the particular implications of the broad principle for particular cases are determined by resorting to the body of doctrine that is developed, which gives effect to aspects of that principle in particular types of situations and relationships. 3. It is appropriate to recognize a new common law duty that applies to all contracts as a manifestation of the general organizing principle of good faith, a duty of honest contractual performance, which requires the parties to be honest with each other in relation to the performance of their contractual obligations. 3. Application. The trial judge made a clear finding of fact that Can-Am, quote, acted dishonestly towards Bhasin in exercising the non-renewal clause, end quote. There is no basis to interfere with that finding on appeal. It follows that Can-Am breached its duty to perform the agreement honestly. The immediate dispute in this case centered on the non-renewal clause contained in Clause 3.3 of the 1998 agreement, which Mr. Bhasin entered into in November 1998. It provided that the agreement was for a 3-year term and would be automatically renewed unless one of the parties gave notice to the contrary at least 6 months before the end of the initial or any renewed term. The factual matrix in which the judge made her finding of dishonest performance is complicated, and I will only outline in very broad terms in order to put that finding in context. There were 2 main interrelated storylines. The first concerns Mr. Hrynew's persistent attempts to take over Mr. Bhasin's market through a merger, in effect a takeover by him of Mr. Bhasin's agency. The second concerns the difficulties, beginning in early April 1999, that Can-Am was having with the Alberta Securities Commission, which regulated its business and its enrollment directors in Alberta. The commission insisted that Can-Am appoint a full-time employee to be a PTO responsible for compliance with Alberta securities law. Can-Am ultimately appointed Mr. Hrynew, with the result that he would audit his competitor agencies, including Mr. Bhasin's, and therefore have access to their confidential business information. Mr. Bhasin's refusal to allow Mr. Hrynew access to this information led to the final confrontation with Can-Am and its giving notice of non-renewal in May 2001. Can-Am, for its part, wanted to force a merger of the Bhasin agency under the Hrynew agency, effectively giving Mr. Bhasin's business to Mr. Hrynew. It was in the context of this situation that the trial judge made her findings of dishonesty on the part of Can-Am. The trial judge concluded that Can-Am acted dishonestly with Mr. Bhasin throughout the period leading up to its exercise of the non-renewal clause, both with respect to its own intentions and with respect to Mr. Hrynew's role as PTO. Her detailed findings amply support this overall conclusion. By early 2000, Can-Am was considering a significant reorganization of its activities in Alberta. By June of that year, it sent an organizational chart to the commission showing that Mr. Bhasin's agency was to be merged under Mr. Hrynew's, but it had said nothing of this to Mr. Bhasin. The trial judge found that these representations made by Can-Am to the commission were clearly false, if, as she concluded, they intended to refer to Mr. Bhasin. She also found that Can-Am, by June 2000, was fearful that the commission was going to pull its license in Alberta and that it was prepared to do whatever it could to forestall that possibility. Quote, however, it was not dealing honestly with Mr. Bhasin about the realities of the situation as it saw them, end quote. In August 2000, Mr. Bhasin first heard of Can-Am's merger plans for him during a meeting with Can-Am's regional vice president. But when questioned about Can-Am's intentions with respect to the merger, the official equivocated and did not tell him the truth that from Can-Am's perspective, this was a done deal. The trial judge concluded that the official was not honest with Mr. Bhasin at this meeting. When Mr. Bhasin complained about Mr. Hrynew's conflict of interest in being both auditor and competitor, Can-Am in effect blamed the commission, claiming that the commission had rejected its proposal to appoint a third-party PTO. This was not truthful. Can-Am failed to mention that it had proposed to appoint a non-resident of Alberta who was clearly not qualified according to the commission's criteria, or that it had decided to appoint Mr. Hrynew, even though he did not meet the commission's criteria either. It also misrepresented repeatedly to Mr. Bhasin that Mr. Hrynew was bound by duties of confidentiality and segregation of activities in the course of an audit, when in fact there was no such requirement. Can-Am did not even finalize its PTO contract with Mr. Hrynew until March 2001, and, notwithstanding its assurances to Mr. Bhasin, it failed to include such a provision in the contract. As the trial judge found, Can-Am, quote, could not possibly have missed this honestly in the PTO agreement, given that Mr. Bhasin's very protests about Mr. Hrynew's appointment as PTO were about confidentiality and segregation of activities, end quote. The trial judge also found that Can-Am repeated these lies about Mr. Hrynew's supposed obligations of confidentiality even after the PTO agreement, without these protections, had been signed. Can-Am pushed on with the requirement that Mr. Hrynew audit Mr. Bhasin's agency as if it were required to do so by the commission, even though it had arranged to have one of its employees conduct the audit of Mr. Hrynew's agency. As the trial judge found, this dishonesty on the part of Can-Am was directly and intimately connected to Can-Am's performance of the agreement with Mr. Bhasin and its exercise of the non-renewal provision. I conclude that Can-Am breached the 1998 agreement when it failed to act honestly with Mr. Bhasin in exercising the non-renewal clause. Liability. C. Liability for civil conspiracy and inducing breach of contract. In light of this conclusion, I agree with the Court of Appeal's rejection of Mr. Bhasin's claims based on the tort of inducing breach of contract and unlawful means conspiracy. The trial judge specifically found that Mr. Hrynew did not encourage Can-Am to act dishonestly in its dealings with Mr. Bhasin, and that Can-Am's dishonest conduct was not fairly attributable to Mr. Hrynew. It follows that Mr. Hrynew did not induce Can-Am's breach of its contractual duty of honest performance. The trial judge dismissed the claim for conspiracy to injure, and there is no basis to interfere with that finding. However, the trial judge held the respondents liable for unlawful means conspiracy, with the unlawful means being the breach of contract and inducing breach of contract. Because, in light of my conclusions, the only relevant breach of contract in this case is the breach of the duty of honest performance, and there was no inducement of breach of contract, the only relevant unlawful means pertained to Can-Am alone, and not to Mr. Hrynew. Accordingly, there can be no liability for civil conspiracy. I therefore agree with the result reached by the Court of Appeal that there could be no liability for inducing breach of contract or unlawful means conspiracy. It follows that the claims against Mr. Hrynew were rightly dismissed. D. What is the appropriate measure of damages? I have concluded that Can-Am's breach of contract consisted of its failure to be honest with Mr. Bhasin about its contractual performance, and in particular with respect to its settled intentions with respect to renewal. It is therefore liable for damages calculated on the basis of what Mr. Bhasin's economic position would have been had Can-Am fulfilled that duty. While the trial judge did not assess damages on that basis, given her different findings in relation to liability, she made findings that permit this court to do so. The trial judge specifically held that but for Can-Am's dishonesty, Mr. Bhasin could have acted so as to retain the value in his agency. In reaching this conclusion, the trial judge was well aware of the difficulties that Mr. Bhasin would have in selling his business, given the almost absolute controls that Can-Am had on enrollment directors, and that it owned the book of business. She also heard evidence and made findings about what the value of the business was, taking these limitations into account. These findings, in my view, permit us to assess damages on the basis that if Can-Am had performed the contract honestly, Mr. Bhasin would have been able to retain the value of his business rather than see it, in effect, expropriated and turned over to Mr. Hrynew. It is clear from the findings of the trial judge and from the record that the value of the business around the time of non-renewal was $87,000. The defendant's expert at trial valued Mr. Bhasin's business as of 2001, the time of non-renewal, as approximately $87,000. While there was some confusion in the record about the date of evaluation and the relevance of discounted rates, I am persuaded that the trial judge found that the business was worth $87,000 at the time that the agreement expired, and that she made this finding fully alive to the difficulties standing in the way of a sale of the business, given the contractual arrangements between Can-Am and its enrollment directors. In addition, we have had no suggestion in argument that this figure should be reassessed. In fact, the defendants, as appellants before the Court of Appeal, submitted to the court that if damages were payable, they should be assessed at the value of the business at the time of the expiry of the agreement, and noted that the trial judge had accepted the evidence of their expert witness, Mr. Bailey, that the value was $87,000. I conclude, therefore, that Mr. Bhasin is entitled to damages in the amount of $87,000. Part 4. Disposition. I would allow the appeal with respect to Can-Am and dismiss the appeal with respect to Mr. Hrynew. I would vary the trial judge's assessment of damages to $87,000 plus interest. Mr. Bhasin should have his costs throughout, as against Can-Am. There should be no costs at any level in favor of or against Mr. Hrynew.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.